My name is Jed Stabler. I'm a partner in the law office of Stabler and Baldwin. I concentrate my legal practice in the area of estate planning, including probate administration and the administration of trusts. I've been practicing here in South Florida for approximately 15 years now. Having started my firm back in 1999 here in the West Palm Beach area. We provide legal services all over South Florida, Palm Beach County, and the state of Florida. You know, a revocable trust agreement is a great thing. It's nothing more than a will substitute. That is to say, just like a will, in it you're going to name who your beneficiaries are, how you want those assets distributed, but it's way better than a will because unlike a will, it avoids the probate, it avoids the time and expense associated with probate, makes it very easy when it comes time to distribute your assets. As I mentioned, you know, a revocable trust agreement is nothing more than a will substitute. But one of the great benefits to having a revocable trust agreement is that it avoids the probate. Probate is the legal process by which a will would normally need to be submitted to the court. It's time-consuming, it's expensive, and a revocable trust agreement helps to avoid that. Not only does it help to avoid the probate, but it also helps to plan for incapacitation because unlike a will, it allows you to name somebody right in the document who's able to act for you and do for you and on your behalf with regards to trust assets and trust matters during your lifetime. It's a very efficient way to plan for incapacitation. Another benefit to having a revocable trust agreement is that you're not limited in terms of who you can name to be the person to distribute the assets. With a will, remember, you're limited. That is to say, that personal representative or the executor must be qualified. Here in the state of Florida, that means that that person either has to be a Florida resident or a blood relative or a financial institution with trust powers. You're unable to name that best friend, for example, that you've had for the last 30 years that still resides up north to be your executor, to be your successor trustee, to be the person whose job it will be to distribute the assets. With the revocable trust agreement, you can name almost anybody. You're not, like I said, you're not limited in terms of who you can name as that person. There are other benefits as well, but those are, you know, the biggies. You know, avoids the probate, avoids the time and expense associated with probate, helps plan for incapacitation, and in large parts doesn't limit you in terms of who you can name to help distribute the assets. Unfortunately, there aren't a whole lot of tax advantages when it comes to revocable trusts. Revocable trusts are what are called grantor trusts, which means that the assets in a revocable trust agreement are treated as if they're out there in your name alone. So it's not going to afford you any sort of tax advantages, except to say that with a revocable trust agreement, remember, everything gets done under your own Social Security number. So it's not like an irrevocable trust where you have to go out and obtain a separate tax identification number. I guess the one advantage would be that, you know, the revocable trust agreement, unlike an irrevocable trust, doesn't require you to obtain a separate tax identification number. So you don't have to file any special income tax returns. Everything remains under your own Social Security number, and the tax returns would just get filed just like they normally would. And some would say, sure, that's certainly an advantage to having a revocable trust agreement. Thank you for joining us today and watching our video. I hope you've learned a little bit about what we do and revocable trust agreements and probate. Please feel free to contact the firm either via telephone at 561-471-7100 or through our website at jedastablerpa.com.